Download Tarang online radio app from Google Play Store.
आप सुन रहे हैं तरंग डिवोशनल,
आध्यात्म से जुड़े
Now we're gonna hear from Sapna on an issue that I don't think has gotten a lot of attention in commentary. So this may be one of the first times we'll hear a real analysis of the issue of two-tier arbitration clauses.
Thank you, Steve. May I also thank the Nani Palkivala Centre for inviting me to be here today and asking me to join this panel. It's a real pleasure to be here, but also a privilege. Now, before I address the topic of two-tier arbitration clauses, I want to step back and take a big picture view to add some context and colour to the topic. And in order to gain some perspective, I'd like to delve a little bit into the annals of history and look at why and how commercial arbitration commenced. So as you all know, arbitration began as an economical and informal alternative to litigation. It was particularly well suited to trade disputes, where parties wanted a fast and inexpensive resolution to their dispute by a specialised tribunal who understood the subject matter of the dispute. In England, it emerged as a preferred dispute resolution mechanism of merchants, and specialised arbitral bodies sprung up to assist with the arbitration of disputes arising from different commodity trades. The Grain and Free Trade Association, or GAFTA, is just one example of such a body. A little closer to home, in India, the resolution of disputes by the panchayats is a form of arbitration which has been around for centuries, which offers a cost-effective and final resolution to disputes, generally without appeal. So as arbitration has evolved, the absence of any appellate mechanisms has been an attractive feature of the arbitration process. It promised to keep costs low and help parties achieve finality more promptly. But since the development of commercial arbitration, from its fairly modest beginnings, it has morphed into a much larger and more unwieldy species of dispute resolution. Whilst the absence of an appellate mechanism developed as a feature of arbitration to help reduce costs for parties and increase certainty, some commentators and critics of international arbitration feel that paradoxically it has in fact increased costs. With no appeal process, parties approach the arbitration process as a one-shot contest where the winner takes it all. There is no second chance for a favourable outcome, so parties pour all their resources into the battle. They leave no stone unturned and no point unargued, just like the arbitrators, as Lord Goldsmith mentioned this morning in his speech. So by contrast, in the traditional court mechanism, issues would be crystallised, filtered, fine-tuned, as a case passes through first instance proceedings and then the appellate process. So by way of introduction, I raise the general question: is some sort of appeal process now, in fact, a welcome, maybe even necessary feature of modern commercial arbitration? So with that conceptual question left for you to digest, I'm going to look a little bit at the nuts and bolts of two-tier arbitration. So I'm going to look at what is two-tier arbitration, is it permissible in India, and is it feasible in India? In fact, generally. So what is two-tier arbitration? Well, I put a definition on this slide. A two-tier arbitration clause provides for an arbitration mechanism in two stages, where a party has an option to appeal the first award to another tribunal. Now, I use the word appeal loosely there because the review process you have in two-tier arbitration is generally very different from what we understand as the features of an appeal process in litigation, and I'll address that again in a moment. So what kinds of institutional two-tier mechanisms do we have? I've mentioned a few on this slide. There's JAMS, a US centre, GAFTA, which I've already mentioned, Lloyd's Standard Salvage, and then also a couple of the sports arbitration bodies. And they're just a few of the most well-known examples. So what kind of appeal mechanism do they offer? Is the review mechanism an appeal in the traditional sense of the word, where there is a review of the first decision? Or are we talking about a de novo review, essentially a fresh decision? Well, JAMS is probably most like an appeal mechanism that we're more used to. It allows the appeal panel to apply the same standard of review that the first level appellate court in the jurisdiction would apply. But for CAS and GAFTA, it's essentially a de novo review, a fresh decision. So one of the other features of a traditional appellate mechanism, apart from an appeal review process, is that a first instant decision is usually appealed to a more senior appeal bench, a more seasoned tribunal, which is expected to have a greater chance of getting it right. So what do we have in institutional two-tier arbitration? Well, for GAFTA, you'll always have more arbitrators in your second-tier arbitration than in your first. So if you had a sole arbitrator, you'll get 3 arbitrators on appeal. Appeal, again, I use the word loosely. If you have 3, you'll move to 5. But for JAMS and CAS, you'll always have 3 arbitrators in your Tier 2 arbitration, but you can have 1 or 3 at first instance. So moving on to the question, is two-tier arbitration permissible in India? Well, of course, the leading authority in India on two-tier arbitration clauses is Centro Trade Minerals and Hindustan Copper Limited, which I'll call HCL. And I've put on this slide the clause, the arbitration clause in that case, which had a two-tier mechanism. The first mechanism was a domestic arbitration in India under the rules of the Indian Council of Arbitration. And then if either party disagreed with that arbitration result, they would have the right to appeal to a second arbitration in London under the rules of the ICC. So what happened in this case is that the claimant lost the first arbitration, the first domestic arbitration, and commenced a second arbitration, which it won, with an award of damages in its favour. The respondent, HCL, argued that the clause was not permissible under the laws of India and appealed this decision to the Supreme Court. A 2-judge bench of the Supreme Court was divided on whether or not the two-tier arbitration clause was permissible, and so that decision was itself appealed to a 3-judge bench. And the 3-judge bench held that two-tier arbitration clauses are permissible in view of party autonomy being of paramount importance. Now, I've put on this slide an excerpt from the judgment, but I'm going to read out to you my favourite part of the judgment, which is in the conclusion, where the Supreme Court said, "We are not concerned with the reason why the parties, including HCL, agreed to a second instance arbitration. The fact is that they did, and are bound by the agreement entered into by them. HCL cannot wriggle out of a solemn commitment made by it voluntarily, deliberately, and with eyes wide open." So a resounding endorsement for party autonomy. Now, the issue of whether the appeal award is enforceable or not is currently pending before the Supreme Court. But certainly, the law in India is that these types of two-tier mechanisms will be upheld according to the principle of party autonomy. So lastly, how feasible is two-tier arbitration? I've set out on this slide the advantages and the disadvantages. So of course, an advantage, there's an opportunity for the parties to be reheard if there's a grave mistake in the first decision or a violation of natural justice. They can also be very appropriate for arbitration in industries where the first arbitration can be decided very quickly. So GAFT is an example of that. There's very short timelines and usually documents only. And also, I think sport is one industry where the arbitrations take place very quickly. So you can see why the parties would want to have another bite of the cherry in a second tier. But there are disadvantages. Having two stages will add to the cost and time incurred in the arbitration. And if the scope and timelines of the appeal are not identified clearly, there can be some uncertainty. So there are suggestions as to how you can reduce uncertainty. You can include timelines. You can specify what type of review you'll have in the second arbitration. Will it be an appeal? If so, on what grounds? And I've set these out on the slides. I'm not going to go through them because I think we're running out of time on this panel, but I'd be very happy to send the slides to any of you if you'd wish to have them. What I'd like to end with is 3 points by way of conclusion. The first is that the decision in Centrotrade was clearly right. Party autonomy should be paramount when construing arbitration clauses. And if parties want two-tier arbitration, then they should have it. But if they do so, they need to do so with their eyes wide open. And they would be wise to take some care in drafting their clauses. The second point is that if the two-tier arbitration clause in Centrotrade is permissible, then surely it must follow that the Supreme Court has to find that the second arbitration award in that case is enforceable. We'll have to watch and see, but surely that must be a logical consequence of the first finding. And my final point is this. Whilst party autonomy should be paramount, I have to confess that I'm not quite sure whether two-tier arbitration serves any useful purpose in the mode in which it is usually employed. And what I mean by that is if your second tribunal in your second arbitration carries out a de novo review, so a fresh decision, so no form of appeal in the traditional sense of the word, and your second tribunal is no more likely to reach a better conclusion than your first tribunal, so there's not a greater number of arbitrators or a greater seniority in the composition of your tribunal, all you've really got is 2 consecutive arbitrations with the later award replacing the earlier award. Does this form of two-tier arbitration meet some of the concerns I raised earlier about the absence of an appellate mechanism? Does it provide comfort that the second tribunal is more likely to get it right? In my view, the answer is no. But I look forward to a discussion on my panel and to contrary views of others, including from the audience. Thank you very much.
Download Tarang online radio app from Google Play Store.
You are listening to Tarang Devotional Online Radio.